SJC-11135, Metropolitan Life Insurance Company versus Cotter.
Wait, why don't you wait a bit? Okay.
Good morning. May it please the court. My name is Praveen Shenoy. I represent the insured James Cotter in this matter. As the court's aware, this case is regarding disability income policy. Mr. Cotter, although as the defendant, as the insured, had the burden at trial to show that he qualified for disability benefits. The policy hinges, as you're aware, on one definition in particular, the definition of physician's care. The definition consists of three parts, and it's one part in particular, that one in the middle that says, under prevailing medical standards, which is dropped out of the analysis done by the Superior Court in this case. In other words are dropped out of the reading of this insurance contract. Mr.
Isn't the issue, doesn't it come down to whether that definition clearly indicates that that appropriate care is care that is designed to deal with the condition and get the person back to the prior occupation?
I'm sorry, are you asking?
Well, I mean, doesn't it, at least as I understand the argument of MetLife, that and basically the judge, is that one looks at appropriate care in the context of a disability policy as appropriate medical care under a physician that is designed to deal with the condition and get the insured, or seek to get the insured back to deal with the disability, therefore back to where he or she was before the disability.
Yes, and I understand that to be their argument, but what Mr. Cotter advocates is, let's start with a blank slate. Let's look at what language is in the policy, and we'll go from there. That idea of getting the person back to work.
But isn't the focus of the policy to get the person back to work at the old occupation?
No, Your Honor. If that were the case, then it wouldn't have offered the residual disability that it offers, which says you can get back to work at a different occupation.
Well, but it seems to me implicit in that is the assumption that you can get back to work in a different occupation because it's mitigating your damages, but it's the assumption is that you can't get back to work at your old occupation. That's when you get to residual.
Your Honor, I'm not sure about the mitigation of damages aspect. Under this policy, Mr. Cotter could earn this year almost, I believe it was quoting my brief, $300,000 and still get the full benefits. So the issue of returning to the prior occupation isn't actually addressed in the language of physician's care anywhere. And that's, again, where I think there's got to be some focus on what language is there. And it says the treatment that the physician performs. It's modified by two prepositional clauses. One is under prevailing medical standards, and the other is appropriate for the condition causing the disability. There's nothing in that language that says appropriate for the condition causing the disability is what MetLife considers possible. They never proved it was definite, but possible to send this person back. Now, it's very important to stress that Mr. Cotter, and the Superior Court found this, Mr. Cotter did everything. He followed everything that his physician told him to do.
Right.
And so this is not like all the cases cited by MetLife in which the insured did not listen to their physician. Here we have someone who does what everyone is obviously encouraged to do. The law supports the idea of fostering this doctor-patient relationship. He does what his physician tells him to do. He doesn't look at the policy language for anything at all. He just, throughout the record, it's clear that he just goes to his physician, something's wrong, and he does what his physician says.
Well,
and
he's
so,
clearly aware because MetLife kept communicating with his doctor that Dr. Schouten is saying you need to do CBT, you need to do these things that are going to, may get you back to your old employment. And I take it that the repeated answer of his doctor is he's not interested in his old employment. Isn't that so?
well, I think that's, I don't think that's as accurate. It's his physician is saying that he's not motivated to return, and he's using motivated as discussed in a different way.
I'm sorry, you're right. He's
And-
not
and so-
motivated to return to his
Right.
old position.
As opposed to some of these other cases that MetLife cited where the person did not want to go back. Here we have someone who had every reason to go back. Unlike MetLife saying, oh, you just want to sit home and get $60,000 a year in benefits, he was getting an average of $60,000 a month, according to their formula for his income. If you take their formula for what he was earning, his earnings per month was $60,000. Why wouldn't he want to go back to work if he could? And so, I mean, again, they didn't prove that CBT would send him back to work. CBT isn't even a form of medical treatment. Their own physicians don't even use CBT. Just as a matter of having them say, okay, CBT will send him back. No, that's not what it says. It says probably, maybe. They weren't certain at trial. Dr. Schouten didn't know how it would be applied.
But I mean, I take it, if you, this isn't what happened, but presumably if CBT had been tried and didn't work, your client would be in the position of saying, I tried it. That's what you said to do. I tried it. I'm still anxious. I still can't, I cannot deal with the pressure of my old job. Can't do it. Doctor says she's right. Can't do it. I mean, we would have a different case, wouldn't we?
We would. We would have a case, Your Honor, in which the insurance company is playing doctor, that we would expect Mr. Cotter, someone with a psychiatric disability, to be in a position to say to his physician, you know what, I don't like your treatment anymore. I'm going to do what MetLife tells me to do. Can that be a fair burden? And Mr. Cotter suggests, no, it can't. He can't be forced to pick between the two. And at the same time, the spirit of the policy, as is clear in this court's decisions for almost 80 years, people buy insurance. It's stated in the terms what they have to do to qualify for benefits. What did he have to do? He had to have regular and personal care of a physician. The policy defined what a physician is. There's absolutely clear in the record that it was within the standard of psychiatric care. So he had it under prevailing medical standards. And it was also clear that Dr. Schouten's answers as to the appropriateness of the care were directed by MetLife. They said, other than not returning to that occupation, which Mr. Cotter did try to do. He did try to return to the occupation, and it failed. They asked specifically, other than going back to that occupation, what are the appropriate forms of care?
Well, let me move the question a little bit. If Mr. Cotter was able to return to his previous job, but simply said, a lot's happened to me, I just don't want to go back to that kind of work of being a computer broker. I want to do different things in my life. Would he still be eligible for the disability benefits?
If it was a career move and he was directing his physician to support him in not going back to that work, then yes. And then, no, he would not be disabled, because then he would be controlling the medical decision.
But here, as I read it, you've got the MetLife trying to push Dr. Weiss to say you should be moving him into this cognitive behavioral therapy in order to get him back to becoming a computer broker, and Dr. Weiss is saying, why should I do that? He's not motivated to do that. That's not what he wants to do. So why should I be pushing him into a therapy which is designed to get him to do a job that he says he doesn't want to do? Which I understand is a perfectly sensible thing for Dr. Weiss to say. But how does that play in terms of the whole scheme of disability insurance?
Your Honor, motivated is, as presented in the briefs, has many meanings, and as used in that way, the questions that MetLife asked of Dr. Schouten that were undisclosed used the term motivated to go back. But it's clear that motivated, as again presented, doesn't mean that he doesn't want to go back. It's talking about the psyche, the ability of him to get back into that role, to be prepared to go back. There's more in it. And again, questioning, what it comes down to is the physician treating the patient or is the patient directing the treatment? There's no evidence that Mr. Cotter directed his physician to do that. And they had plenty of opportunities to ask Dr. Weiss that in all the forms that were filled out. The reason for the change in career, in the summer of 2006, before this happened, before they filed declaratory judgment, Mr. Cotter was complaining about the fact that he felt Dr. Weiss was holding him back, and MetLife's claims representative said, well, you have to do baby steps, you have to get back into doing something, you can't, it's okay if you do a different job. And they were encouraging him to do that, to follow Dr. Weiss's recommendations. So the idea that he's supposed to do what his physician says, but at the same time, when MetLife says, no, we don't like that anymore, he's supposed to then fire his physician. I mean, how is anyone going to decide this as a matter of if they were disabled, they follow their physician's advice, and they're supposed to, under the policy, obtain regular and personal care. But
so when Judge Billings says that Dr. Weiss's position was, not unreasonably, I'm treating this fellow, he does, for whatever reasons, I mean, not because he just has chosen not to, but he's not motivated to go back to being a computer salesperson or broker. I'm treating him, I'm trying to deal with his depression, et cetera. That's what I'm doing. That's a finding of Judge Billings.
Correct.
And do you agree with that?
In terms of that he's treating his patient, yes.
And that that basically he's following, Dr. Weiss, is taking the lead from his patient, that he's not, I'm not ascribing any bad motives to your client, but he's not motivated to try to get back to that old position. He's found something that's less stressful, et cetera, et cetera. So I'm supporting him in what he's doing.
Yes, and I believe, Your Honor, that's from a June 2007 letter that Dr. Weiss wrote, where in the first paragraph he said, or around the first paragraph says, I agree with it in the hypothetical. And it's all very helpful in that hypothetical, but then when we're dealing with the actual patient in the real world, with the high stress that's there, it will incapacitate him to go back. So it's not only about, is Mr. Cotter motivated? Let's say that he, to bring up the idea of, is it a career change or not? First of all, he obviously didn't select to have cancer when he did. That's not something that anyone would select. And so it's not a career change in that sense. He wasn't looking to file this claim under a psychiatric disability. It wasn't until the oncologist released him from the point of view of can he go back for that reason that MetLife said, you know what? You've been treating with a psychiatrist. It was December of 2005. and he'd been seeing Dr. Weiss since August, September of 2005. They said, why don't we use that? We'll put it in under as a claim for that. And so he's not seeking Dr. Weiss for the purposes of a disability. And at that time, the idea was get back to doing something. Incapacitated, likely incapacitated if he goes back to work, is Dr. Weiss's opinion. It had nothing to do with whether or not he was motivated. He may have been, however we use the word, he could go back, but it was clear that Dr. Weiss said he'd be incapacitated. And questioning, Judge Billings said he gives deference to Dr. Weiss as the treating physician. Questioning the motives of the treating physician here, where he has nothing to gain one way or the other. He's doing what is necessary for his patient. And I think that's the most important part here, is that no one can say what he didn't meet the definition in the policy and didn't meet the definition of a physician treating a patient.
So you're saying that we should interpret Dr. Weiss's statement to be he is not motivated because if he were to go back, he'll be incapacitated. It would be that the stress would kill him or hurt him.
I believe that the way that Dr. Weiss phrased it was that there's a hypothetical situation that is being addressed from his point of view, and then there's this reality of if he goes back, he'll be incapacitated. And I read them as separate, just going back to that letter in June of 2007.
Thank you.
Thank you.
Good morning. May it please the Court, Joseph Hamilton for Metropolitan Life Insurance Company. Just to alert the Court, there are two issues on the appeal. MetLife also has a cross appeal on the restitution argument, but I'll go to the appropriate care argument first. As has been discussed at length, it really comes down to an interpretation of the policy language, which is the physician's care. And from our perspective, Judge Billings got it right. The phrase at the end of that, it's defined as a regular and personal care of a physician, which under prevailing medical standards is appropriate for the condition causing the disability. Now, Judge Billings found that the only reasonable interpretation of that language really just follows through looking at the policy terms. The condition causing the disability, the condition it's the injury or the sickness, that's the condition. In this case, it was a psychiatric condition causing the disability. In this case, it was the inability to do the material and substantial duties of his occupation and his regular occupation. And that's defined in the policy as well as the job that you're doing at the time you become disabled. So the interpretation flows very simply from the policy, is that we look at the condition, the psychiatric illness, we see is it causing the inability to do your regular occupation, and if so, that's the treatment that you need to have in order to address that disability, that condition.
I hear you, and I read the definition that Judge Billings said was the one he was going to use from the Henry case. I guess where I have a little bit of difficulty is the leap between treatment that is appropriate. I mean, let's just take is appropriate for the condition causing the disability. Well, in this case, it's a sort of depression and anxiety.
Yes.
Okay? So, treatment appropriate for that condition may include therapy. It may include drugs. It doesn't really tell you that what you're really supposed to be doing is treatment that is going to get you back to work. I mean, I understand. It's not as clear as I think you say these cases find it unambiguous. I don't find the leap to it's appropriate to getting you back to work is exactly explicit in that language.
Well, it does say causing the disability.
Yes, but the causing the disability is in this, is the depression and the anxiety. So I'm getting treated, I'm getting drugs, I'm getting Cymbalta and whatever else he was getting, and I'm getting therapy.
Actually, Your Honor, the psychiatric illness is the condition. It's not the disability. The disability is the inability to do your regular occupation. So when the policy requires the physician's care, it's requiring you to have appropriate care for the condition, that is appropriate care for your depression, which is causing you to be unable to do your regular occupation. That's the reading of the policy. And if we take a step back and think of it from a public policy perspective, and also from the perspective of the contracting parties, what is it that the company is doing here? It's saying to the insured, look, we're going to pay you a monthly benefit. The provisions of the total disability clause are very clear. You have to be unable to perform the material and substantial duties of your occupation, and you have to be receiving the physician's care. So the company is agreeing to pay a significant monthly benefit because you're unable to do that. Now, the quid pro quo of that is you need to make attempts to get better, to go back to that job.
No, I appreciate that that's exactly, and it makes all the sense in the world. I just think if I'm the reasonable insured, I'm not sure I would necessarily get that second piece out of that language.
Well, it's always the criticism of the insurance company of you could have said it better, you could have said it clearer. The cases that have looked at these physician care provisions, look back to the older versions. It's the one that's in the Lustenberger case, where it just used to say, well, all you need is regular care.
Right.
And that's really the first half of this definition, the regular and personal care of a physician. Okay, well, we can check that box. He got that. He is seeing a physician, seeing him regularly. And if you just stop right there, you say, okay, Mr. Cotter satisfies the provision. So what does the rest of it mean? Are we saying it means nothing? I don't think we can do that. Well established, we need to take the entire provision and give it some meaning. Well, we give it meaning through looking at the other provisions of the policy. And it's the analysis that Judge Billings did. It's the analysis that other courts looking at this have given it. And really, essentially, what Mr. Cotter wants to do is just take the first half of the definition and say, look, as long as I'm going to a doctor and it's addressing my general malaise, then I'm satisfying the provisions of the policy. And many of the cases that have addressed this type of a provision also had policies involved that had the regular care. And the court in one, the same case will say, okay, look, you win on the regular care provision because you're doing that, but on the appropriate care, you're not, because that raises it to the next level, which means you've got to get the care that gets you back, on the saddle, back to your former occupation. And it's consistent, I think, with the remaining provisions of the policies, the definitions in the policies. You can always argue it could be clearer, but it's certainly, Judge Billings is not making a stretch by reading this language, which is the same as we have done. And we have not been unfair to Mr. Cotter. From the get-go, when Dr. Schouten from Mass General examined him, the information was sent to Dr. Weiss, who shared it with Mr. Cotter, and Mr. Cotter acknowledged he received the report, laid out exactly what the recommendations were for a treatment plan that might get him back to work. And Mr. Cotter has, at trial, consistently tried to, from our perspective, redefine the word motivated. I think the word is well established as to what it means, but if there was any doubt about that, Dr. Weiss wrote to MetLife in response to one of the inquiries that we sent to him on what's happening. He acknowledged that he had received Dr. Schouten's report. He also acknowledged he had discussed it with Mr. Cotter. And he went on to say, this is Dr. Weiss, I'm quoting, Mr. Cotter is not motivated or interested in returning to his former occupation. So to the extent, and there's really nothing in the record that supports the interpretation that Mr. Cotter wants to give to what the word motivated says. There's nothing that says it means something else. And Dr. Schouten testified as to his use of the language. It's in the transcript. And he told Judge Billings what I meant when I put in my report that Mr. Cotter was not motivated to return to his job, that he didn't want to do it. He didn't want it to go through treatment to get back. He didn't have an interest in going back to that job. He wanted to do something different. He can...
Mr. Hamilton, under the terms of the policy itself, if he was willing to undergo the treatment plan that MetLife's doctor had devised for him, and he, went through it and really made an earnest effort to do what was required of him under MetLife's view of the policy, and yet, even if MetLife's doctor had said, "Look, yeah, he's there, but he just can't quite get the ball across the goal line. He's not going to get back to his old work because he's depressed at the prospect of it." What happens in those circumstances under the policy?
Well, he would get his benefits. If I'm understanding your question, Your Honor, there are circumstances, and it happens all the time, whether it's a mental illness, a physical disability. If they're doing the types of treatments that are aimed at returning them back to their regular occupation, and they're unsuccessful, they receive their benefit because the requirement is to get the care. The care may not always work. You may have an operation that's not successful. You may have physical therapy that's designed.
It may not change his attitude enough to do it in this case.
Well, I'm not sure if it would. I think the attitude needed to be changed first. But if you went through the treatment,
The CBT, and it just didn't.
if it wasn't successful, the fact that a treatment is unsuccessful does not disqualify someone from a benefit. The requirement of the policy is you've got to give it a shot. Dr. Schouten and Dr. Dieters, there was no dispute at trial that no treatment is 100% guaranteed. All we can do is come up with the appropriate, the suitable treatments that are aimed at getting you back to work. You've got to give those a run, and if it's a good faith effort and it's unsuccessful, so be it. Then the benefits continue to be paid. But not doing it is not the option. You can't make a choice and say, I'm not going to do it. Where it leaves the company, and in fact the industry, is it then becomes a choice of the insurer to say, look, I'm going to retire. I mean, it doesn't even have to be I'm going to become a teacher. I'm not going to go back to work. I just don't want to do it. I'm receiving my Wellbutrin, and I'm going every 6 weeks to a psychiatrist who's rewriting the script. So I am seeing a doctor, but I've made a decision that I'm whatever, 40, 50, 60, and I've had it. I'm not going to do it. And under Mr. Cotter's construction of the policy, that would be okay. Now, the fact is he chose a different occupation, but there's really no difference. He's saying, I'm going to do something other than attempt to go back to my regular occupation. And from our perspective, that's not what the policy provides. If you want a total disability benefit for your own occupation, you have to try to get back to your own occupation. That's all it asks.
But I gather you're not challenging that he presently is disabled in terms of returning to his previous occupation.
Well, actually, Your Honor, there was a testimony from Dr. Dieters, who had done the neuropsych, that he didn't find him to be depressed when he did his examination several years ago. We did not get into...
But that's not the basis for your...
That's right. We did not get into the issue at trial as to whether or not he would then currently qualify for the policy. Based upon the condition, our view was he wasn't receiving the appropriate care. And that was the only focus.
But and I guess what you want appropriate care to mean is not only appropriate care for a psychiatric condition, but appropriate care for that condition that is designed to get him back to his previous job.
Right.
Exactly. Appropriate care for the condition causing the inability for you to return to your own occupation.
Your occupation.
I mean, the condition he has is a psychiatric condition.
Agreed.
To characterize differently, but at least I think by your expert, as an adjustment disorder.
That's right.
The treatment he's receiving is appropriate by Dr. Weiss for somebody with an adjustment disorder. No one is
Using it in a general sense, yes.
I mean, in terms of under prevailing medical standards, you don't have anybody saying that what Dr. Weiss is doing is not consistent with prevailing medical standards for somebody who's suffering from that kind of disorder.
No one testified that it was committing some sort of malpractice or anything of that nature. No, Your Honor.
Just not going to get him back to where he was.
Right, because the condition, the definition says appropriate.
It's appropriate for the condition causing
The disability. And so we can take the word appropriate by itself and say, well, and even looking at the Dabari case, for instance, where someone was getting a cortisone shot rather than, and it wasn't, he got it, it's not an inappropriate treatment, but it got to the point, well, if you're going to return this individual back to work, he needs more. Court agreed that, yeah, you've got to go to the next step where you have a treatment that is not going to do you any harm, which is designed to get you back to being not disabled, because the provision says the condition causing the disability. In that case, the treatment is inappropriate. And both Dr. Schouten and Dr. Diers did testify that in addition to Dr. Weiss's admission that Mr. Cotter was not motivated or interested in going back to his occupation, the treatment that Dr. Weiss was administering was not appropriate to get him back to his regular occupation.
Could you address your second question?
Yes, very quickly, Your Honor. It's a restitution argument. When we filed the declaratory judgment action, it was specifically told to Mr. Cotter that, look, we're going to continue to pay you benefits. However, if a court agrees with us that you are not entitled to them from this date forward, we will ask you to pay them back.
Does the policy contain language to that effect?
It does not. And I'm not sure that there is insurance policy that I've seen that does contain that. It's an unjust enrichment. We did put in reservation of rights. Judge Billings is completely correct. There's no provision in the policy. However, this case law which we cited in the brief, in which in circumstances in which, one, you give fair notice to the insured that you're reserving your rights and that you are going to ask for the benefits back, and that keeping those benefits would be a windfall. In this case, it is, because it's been established he was not entitled to it.
Cases that you cite, that none of them have language in their policy, is that what you're saying?
That's my understanding, Your Honor, yes. These were all cases done based on equitable grounds, that the company is entitled to recover the funds. So that's what we relied on at trial. Judge Billings looked at it as, if it's not in the policy, you don't get it. We think that this is really a four-square case of unjust enrichment. And the policy reason why we've pushed this, Your Honor, is that it puts the company and the industry in the difficult position of saying at the beginning of this, all right, we now have to cut you off from benefits, obviously into a breach of contract claim, but more importantly, in this jurisdiction and others, you get a Chapter 93A or a bad faith claim, which then takes the case to a completely different level on discovery, on trial, et cetera. What the company was trying to do is say, let's keep the issue on whether or not you satisfy the policy definition. We'll go forward in good faith and continue to pay the benefit with the warning to you that if you're found to be ineligible for those benefits, we're going to ask you to pay them back.
But even if you're right as to the law, that is, even if you could maintain that claim in the absence of policy language, do you disagree that a judge could arguably say, looking at the equities, the burden upon the insurer to pay that back is going to be so great that I don't consider it to be equitable in view of his means and the problem of repayment?
I haven't seen that element come into play, Your Honor. I frankly believe that Judge Billings took that into consideration, and I think I understand why he did that. My concern is that from a policy perspective, without specifically articulating that as a factor and just placing it solely on the policy language, he's basically kind of painted the insurer into a corner to say, well, you can never get it, regardless of whether you're dealing with someone who put the money in the bank or is a millionaire or it's a de minimis amount. So if that's going to be the analysis, you've at least got to say it, and you've got to then tee it up to see whether or not it's supportable. He didn't do that. He's made a categorical decision that you can't do it if it's not in the policy, and I think that takes away the equitable argument that the insurer has in all these cases to say, in these circumstances, it would be inequitable to allow him to retain the benefit. Thank you very much.
Thank you.